Before deciding whether to take on a guardianship, it's important to understand key factors and gather information to determine if it's the right choice for you. What is a guardian? A guardian is a person who has been appointed by a court to care for and have custody of a minor child. Traditionally, a guardian has been a person, usually a relative or close family friend, who has assumed the care of the child. What does guardianship mean? Guardianship is a legal process which protects a child who is unable to make decisions about food, clothing, shelter, safety, or other care. Parents of the child are the natural guardians, but sometimes parents are unwilling or unable to be the guardians. When this happens, courts can appoint another person to be the guardian of a child. This may be the case when the child's parents have passed away, both parents are unwilling, unable, or unfit to be the guardian, or parental rights have been terminated. Who can be a guardian in Missouri? Courts will consider if a guardian is suitable before appointing them. A guardian must be someone who provides a stable and permanent home. The court will consider what is best for the child in that child's specific circumstances. A child over 14 years old may be eligible to select a guardian if their parents are not capable of caring for them. A child over 14 years old must also consent to the guardianship. Types of guardianship. Temporary guardianship. If a child's parents are unavailable for an extended amount of time, temporary guardianship can be put in place, so a child can have a guardian for the time being. This action does not take away parental rights over the child, but it does ensure the child has a decision maker for the time a parent may be unavailable. A court can set the time limits on how long the temporary order lasts. Standby guardianship. A standby guardian is someone chosen by the child's parent to handle the care of the child in case it is needed for any reason. Guardians will temporarily assume the duties for a brief period while parents keep their parental rights. To be effective, you need to file an acceptance of the guardianship within 30 days of the court's confirmation and appointment. Permanent guardianship. A permanent guardian is meant to form a permanent family for the child without having to terminate parental rights of the child's parents. Permanent guardians fill the role of a parent and will provide for the child's care and day-to-day needs. How do you get appointed? Each case and its timeline can vary, but the general process for guardianship includes: 1. File a petition of guardianship with the court. It should detail why the guardian will be the best choice for the child. 2. Provide the court with documents and information explaining why the birth parents are unfit to care for the child and why the guardianship is the best option. 3. After the petition is filed, the court will schedule a hearing. At that hearing, the judge will hear all the evidence and decide on whether the birth parents cannot care for the child or if the child cannot care for themselves. 4. If the judge finds the parents are unfit and the guardian is the best for the child, the judge will appoint a guardian. What to expect in court. Once your case is called, wait to see if your attorney asks you to come forward. If you are applying for guardianship on your own, stand up and wait for the judge to give you instructions. If your case is expected to take a while, the judge may put it on what we call a second call, meaning it will be heard later to let shorter cases go first. After the judge dismisses you, you are free to leave the courtroom. You do not have to stay until all of the other cases on the docket are finished. Wear pants or knee-length skirt or dress, and pair it with a tucked-in collared shirt, blouse, or sweater. Pants should be worn at waist level, and closed-toed shoes are required. Always refer to the judge as Your Honor or Judge. Avoid speaking over the judge and be mindful of your actions and reactions while in the courtroom. It is important to present the facts of the case to the judge, such as dates and times of parent visitation, phone calls, child response to interactions with parents, and more. This is to ensure the judge understands the presence of the parents in the child's life. Remember, the judge has a duty to determine the best placement for the child. Understanding your responsibility. You are responsible for the child's daily care, including health, education, and welfare. You have the authority to make medical decisions on behalf of the child, such as approving treatment and surgeries, unless the court has limited this power. You also have the authority to enroll the child in school, interact with their teachers and school counselors, and monitor how they are doing in school. It is important that you provide for the child's emotional and social needs, ensuring the child has access to counseling and therapy if needed. As a guardian, you must file an annual status report with the court outlining the child's health, living conditions, and well-being update. This report is typically due each year on the anniversary of your guardianship appointment. Guardianship renewal and yearly requirements. Once established, a guardianship generally continues unless it is terminated by the court. However, courts require guardians to follow certain procedures each year. Courts require an annual status report outlining the child's health, living conditions, and how they are doing while in your care. The report is typically due with the court each year on the anniversary of your appointment. This allows the court to ensure the guardianship is still in the best interest of the child. If the annual status report is not filed, it could lead to termination of the guardianship. How is a guardianship terminated? There are many ways a guardianship may be terminated. This includes when the child turns 18 years old, the court finds that the child can make decisions for themselves, the child can petition the court at any time to end the guardianship, or the guardian can resign by asking the court to appoint a new guardian. Resources available. Mediation is a way for people to talk about family problems and find answers together. A person called a mediator shows them how to listen to each other, resolve conflict, and make decisions that are in the best interest of the child. Mediation is not the same thing as legal representation. Financial resources. Guardianship subsidy payments may be available to kinship caregivers who have legal guardianship. These subsidies can provide financial, medical, childcare, and respite services to help meet the needs of the child. For a guardian to be eligible for guardianship subsidy, they must have a relationship with the child, be a licensed relative home provider through the Department of Social Services. For the child to qualify for a guardianship subsidy, they must be under the age of 18 at the time of placement, be in the custody of the state or a child placing agency, and are unable to return to their parents' home.